Hi, everyone. Good evening. Carl Steinbeck here. We got, what is this, Tuesday night here, June 3rd, and we had day 26, Commonwealth, Massachusetts versus Karen Reed. And it's very much a day that's hard to take, hard to stomach this, because you had the most honorable Dr. Marie Russell continuing on the witness stand from yesterday. And it's something that I'm not used to seeing in a court of law, people being treated this way, especially somebody as highly esteemed, highly reputable, and someone's had a lifetime of service to people with critical medical needs. So the way this was conducted here in this so-called court is more like something you'd expect to see maybe in some kind of communist country where everything about the rule of law is just an illusion. So with that, I'm going to go ahead and get right into this. This is the coverage we see on Boston 10. So
May I?
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday.
well, why didn't you just say your last name? Good morning, doctor. You know, he doesn't talk that way to his own doctors. You notice the difference there? Those little clues like that show what kind of phoniness attorneys have in the courtroom. And so he's he's definitely a way of making a dig at her and not showing her proper respect. Keep in mind, this lady is probably around 70 years old, and she's coming here and she spoke out and reached the district attorney's office in LA because she knew the district attorney there, and she wanted to have some input in this case to help people understand dog bites because she knew that Karen Reed is being railroaded. So anyway, that's just some of the backdrop in case you missed it yesterday. So let's go ahead.
Today, if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
Like that would change what her opinion is. He always is trying to look for any possible angle to try to make her look like she's not credible. So all the stuff he's thinking that she's doing is this kind of stuff that he's thinking of doing behind the scenes to try to manipulate the evidence. Yeah. Yeah, I'm sure, Monique, he's definitely feels the pressure, and he knows he should lose his case. That's why he's thinking if he just mows everybody down for the defense, that that's his best shot to win, but he doesn't realize that he's actually shooting himself.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered.
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Alessi.
And Mr. Alessi, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so, did Mr. Alessi help you with your report?
What I recall is we discussed the report, but
You see what he's trying to imply, that Alessi did something wrong? And think about what he did. He interjected to call an Aperture to get them to change their report. So the very thing he's trying to make it look like it's devious and sneaky and underhanded, and these people have no credibility on the defense, is the very thing he does, and just is openly and arrogantly acting like this is normal for him to do it. But anybody else that does any kind of help and prepare stuff, he was doing that, keep in mind, after the discovery period had closed. So he's not allowed to do that. And so he's acting to the judge that he just suddenly got an updated report that he didn't ask about or inquire ahead of time. So all that is deception. And so think of that when you hear him talking to her this way.
I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Ruthless.
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have?
I mean, they're not stupid. I mean, Alessi works for a global law firm, DLA Piper. They're around the world. He is not going to jeopardize something and make stuff up. He doesn't know this kind of medical stuff like she does. So he's going to really tell her how it needs to be written from a substantive medical standpoint or pathology standpoint. Come on,
Have
really?
any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you just
please.
testified to. You want to
Yes,
see it again?
yes.
Okay. And by the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
Look at that. He's so concerned about what stuff the lawyers might have asked her. He's trying to just get into every single little possible detail. He's that worried about losing this case. Of course, you would talk to her attorney and say, hey, look, here's what you might want to do. This is what Brennan's style is. He's going to do ambush you. So if he tries to trip you up, I mean, that's a normal thing an attorney would do. So why would you even be worried about somebody like her? Look how she's looking at him like, I know you're acting this way because you are, well, I'm not going to say it, but she knows his character. That's all I'm going to say. So she's smart enough to be onto this guy.
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Wow.
Well, I think it was just Mr. Alessi.
So did you?
Yeah, because they said he's going to trip you up, say you said something you didn't, and then if you think you did, and you can't trust this guy to tell you the truth, in other words. So if you can't trust the attorney to represent what you said in the past, like he's been doing, you got to make sure you ask for the transcript. That's his tactic. So of course an attorney's going to say that. Now he's trying to make it look like, oh, they try to set her up to have some kind of conspiracy to to mislead the jury or some garbage like that.
You and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
A sequestration order that you're not supposed to discuss the case at all with anybody?
Well,
during-
we,
That's not, see, that's a lie right there. You can discuss it with attorneys. A sequestration order never applies to the attorneys. What a disgusting.
we didn't discuss specifics.
Of course you can discuss the case. What I don't know why defense is just letting this get
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
that doesn't apply to the lawyers, dude. I've never seen that apply to the lawyers, so don't try to spin your moves like that.
I understand that there is a sequestration order.
Do you understand the sequestration
it.
order mandates that you're not supposed to speak to people, including the attorneys,
No.
about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I
order
didn't.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who
Oh my
else
gosh.
was in the car when you left
You
court
guys conspired in the car while you're driving to court on how you're going to lie to the jury.
yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday, no. Not in the car yesterday, no.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to this sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case.
Oh, who
What else?
cares?
Not about the Red Sox or the
That's
weather.
all you
What
got.
else did
When you have to talk about this
Attorney
kind of
Alessi
stuff,
about
folks.
This morning, other than you should.
When he's trying to get in this nitty gritty minutia stuff, it just means he's got nothing. He's got nothing of substance. He's just trying to belabor this and harass her and wear her out. And he's hoping that maybe she's going to slip up and say something. But she is super sharp. She knows what this guy is all about. So
You ask for a transcript every time I ask you a question
We talked about what I did last night.
about this case.
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney
why? What difference does it make?
today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking
What a way to be a jerk and badger this poor doctor.
about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask
I-
for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
Wow. Look at that.
No.
May I approach?
Man,
Yes.
sorry.
No. Do it.
Look at
Well,
this.
It was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
Look at that. He's trying to imply that is not being forthright and honest about what they talked about.
No.
Do you have any memory issues?
What a comment. Right there, a judge should have like blasted him. But you know what? This is not a real court of law. This is a tribunal, and they might as well just order the jury to find her guilty because they're not about finding the truth here. They want to verbally abuse and berate people that want to stand up and speak the truth. So shame on this whole scam process. Look at that.
No.
I tell you what, if this jury does anything that this guy asks them to do, then they're done for in Massachusetts. Okay, there's no chance of turning the ship around there from this cesspool of corruption.
May I approach?
Yes.
Look at that. She's thinking, you low down, dirty.
Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but we're going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
That looks consistent.
Okay. You want more time with the transcript?
No.
This is so disgusting, guys. This is so tough to watch for me that in a way I wish I never covered this case because it's just it gets my anxiety and anger up. I don't like to be watching this kind of stuff, and I can't really do anything about it here. So seeing somebody being just trampled all over their rights like this, it's and then they're treating her like this. It's just such a disgrace, and I don't know how anybody even still lives in the state. And I'm seeing messages, and I hear from people saying that they're going to move out, and we're planning to go visit Boston, but never again. So I hope that's the message they get, that the whole place dries up. There's not going to be people paying the taxes for these $322,000 a year so-called police officers to do their job of covering up for all these little towny corrupt people.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at.
Yeah, I'm sure he told that same thing to Jen McCabe. You're right, Norton. The way she played stupid. And then even then, when the transcript was handed to her, she goes, "I don't remember. I can't recall. I don't adopt that." You know why she was doing that? Because he knew he had to back her off. Her making those pinpoint time stamps, like at 12:45, that Karen's vehicle was still out front of the house, and she had looked down at her phone when she texted to see that it was still there. So she had to backtrack all that, and so that's a kind of lying testimony he's propping up before this jury, and then he's going to try to beat her over the head with this innocent talk with her attorney that called her as a witness.
That. Do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes,
May I see the
of
transcript?
course.
Good. You can't
Pursuant
trust
to
a word
Attorney
this
Leslie's
guy
advice,
says.
Let me approach.
Objection, Your Honor.
I'm going to strike that, disregard that, Joyce.
May I approach?
Yes. What page you want, Mr.?
Pursuant to attorney, a large dog.
Oh, catch this.
On that same date?
Yes,
May I see the
of
transcript?
course. Pursuant to Attorney Leslie's advice, let me approach.
Oh, look! Listen to that smart aleck remark. Pursuant to Attorney Alessi's advice. Let me see. Did he say Alessi or Lessie?
Degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes,
May I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice,
Oh, well, the one time he said Alessi because he wanted to shoot that out there real quick. This is such a unprofessional. Basically, it's a it's I can't even describe it, guys. It is like such a low, below the belt, below the knee type of chop, cutting somebody off. It's like he's trying to trip somebody up, like a schoolyard bully that would trip people, let them fall and bloody their nose or break loose a tooth or teeth. That's the kind of guy this tactic is about. And so, my gosh, she said jury will disregard it. You know what? Rather than disregard it, a judge would say, stand down, counsel. You would not talk to another attorney in this courtroom that way. You hear me? Let's call a cyber. And then she should have just ripped into him for doing this kind of stunt. But you know what? This judge works for Morrissey, so that's what we got.
let me approach. Objection, Your Honor.
I'm going to strike that, disregard that, Judge.
Disregard.
Yes.
Why don't you quit disregarding your job, Judge? Why don't you do your job for a change and control the courtroom from this out of control, rogue so-called prosecutor?
What page you on, Mr.?
23.
I can't even stand to watch this, guys. This is so disgusting. You are evil. You're an evil man. Shame on you. You're disgusting to the bar.
Line 14.
Shame on you.
Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty?
People that have this ugly to people, obviously they hate themselves even worse. So that's the one thing you got going for you, dude. Why do you hate yourself this bad? You have to be this vicious, cruel, and hatred, full of hate towards other people.
These injuries were from an animal attack, possibly a large dog. What did you say?
I said yes.
Thank you. Have that back?
Yes, you may.
Okay, thank you.
Yeah, just yeah.
When you gave your opinion,
Disgusting.
not this
You guys
year,
are
last
sick.
year,
Sick people.
you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it?
Sure.
That sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes?
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
But she wrote the book on it basically because she's done so much of this line of work. She's probably the world's #1 expert on this.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
Okay, I think what is going on here is, as a defense attorney, you're not going to win really an objection from the judge. That's going to put him in his place. Number two, his abusing of this wonderful doctor should backfire big time. If the jury doesn't understand what character this attorney has in court, then they will definitely see it through this Dr. Russell. So let him verbally abuse her like this, and then have that can be, in the end, this is like a strategic move to let him get away with it. Not like I say, not that she's going to do anything anyway. So this is a tactic. Let him show his true colors, and that's going to help him alienate himself to the jury because he doesn't know the first thing about how to connect with the jury. I guarantee he just sits there in his chair, never looks at the jury once. Think about it this way. He's so far up close to the judge's bench also. He's never looking back. He'd have to turn his head like all the way back like this to even look at the jury to really see what they're picking up on. And so he's just looking straight ahead. It's almost like there's not even a jury in the room. It's just like he's just doing whatever he wants to try to go around the room and just smacking people around like this. So in the end, he's going to lose. So just got to look at it from the strategic standpoint, not this short-term, torturous beat down that this sweet doctor's having to endure. But she holds her ground. She's awesome.
Okay.
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer-reviewed articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer-reviewed articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point?
You shouldn't need it. It's pretty obvious. And most people know if they've been attacked by a dog. That's why it's so rare. But because she worked in a place where you had inmates, she got to see the canine dogs make bites on inmates, and that's how she got so experienced on knowing what they look like, not just looking at textbooks.
Point to any.
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. DeMunick, and the article with the lead author of Dr. Pollock. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, where there is a readily
Yeah,
accepted
boys.
standard in the dog bite community for identifying dog bites?
No.
Going round and round. Same thing over and over again.
And so with no readily accepted standards in the dog bite community,
Yeah.
no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make, and nurse practitioners and the like, make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites
Smart
here.
aleck.
So let's focus on dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology.
Yeah, he's
and
doing a
since
form
there
of
is
badgering
no
at different times.
accepted and
Absolutely.
approved guidelines, you are essentially simply looking at a picture, a photo.
His whole personality is just contemptible, okay? The jury should be absolutely turned off and disgusted by his behavior here.
Photograph and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the method and the articles that I read, the numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No,
The thing is, he's going to call this Crosby guy who's got nothing compared to her, and yet he's going to try to vilify her. It's just, like I say, everything Hank's accusing somebody else from the defense of doing, that's what he's all about, when he's actually the one doing it.
the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You don't need to have a standard methodology because it's so patently obvious that this is a dog bite.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out. You sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches? and abrasions and wounds. What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
That's the kind of stuff he does to witnesses, like with Jen McCabe, huh? How about that?
Oh.
They should have, yeah, that'd have been funny with some of the comments here. That'd be funny if she would have said, I've seen it from with my own eyes, the way you try to twist words around.
I would like to put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for the sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
Julian Nielsen says, unfortunately, someone want to hire him for his analysis. Yeah, that's the thing. Lawyers will get clients because they know that they do this kind of a nasty treatment towards witnesses and beat up on the government witnesses this way as defense lawyers. And so they think that's a good thing, but in the end, they alienate the jury. So they wind up doing work. They're worse off. That's what I see.
4?
Yes.
5?
Which did you call
sorry, this
4?
one.
4,
5.
5, 6, maybe.
Okay. So as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay.
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you
That's more
testified
than
June 18th of 2024, last
the
year,
elbow.
when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion-
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape. And very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar-looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth
He just called it a premier expert on dog bites in the United States. Wow.
and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No,
It wasn't until I
There's
began
a
asking you
spin.
questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying, I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that in the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
I mean, dogs, they go up and they attack with their teeth. They're also got their claws there while they're biting. If you notice that that's what dogs do, is they go after arms, and people try to use their arms to block. So the canine dog is trained to go for the arms, and the arms is how they're going to bring a person down. That's just automatically their way of neutralizing someone that the cops are trying to take down. And this is exactly the same kind of pattern you see. So for him to spend all this time trying to make her look like she doesn't know what she's talking about, which he's not able to accomplish that at all. She's just impeccably brilliant. And I mean, this stuff is just common sense, right? So these on the lower part of the upper arm, these two scratches that are close to each other, like you don't know for sure if those are done the same time by like by the claws. I mean, I would think maybe those are claws, and then maybe the bigger, deeper gashes are the ones that are the further up the arm are done by teeth. But I mean, we don't know exactly how it happened, and you can't recreate it strike by strike. The bottom line is he died trying to defend himself from a canine.
Those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that there was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog oftentimes or most times are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point.
I've never seen a witness do that, but the judge is not stepping in. And so if she did that, that would be really cool to see. But on the other hand, if he changes behavior, maybe he won't come across bad. So the worse he is here, folks, I'm just trying to say, okay, I just got to keep in mind what this is doing in the big scheme of things. The jury is going to continually have nothing but contempt and disgust at this guy Brennan.
They're at the at the end of the paw.
I mean, you really think as a prosecutor you can just act any way you want, and a jury's just going to automatically do what you ask them to do and convict the defendant, no matter how you act, no matter how low you act, and how twisting of evidence around you make it, and the double standards you're projecting. I mean, this guy has zero credibility whatsoever. Zero. And a good attorney has credibility and can win a case with credibility, with dignity and honor and respect of the process. This guy has none of that.
They come to a point, and by the way, the paws can open and close, so the distance between the nails can vary. depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes, depending on the tooth, there's different shapes and sizes, absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later
Mary Stillman.
in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year.
Yes, Mary Steelman. We love Dr. Russell. She has more integrity in her thumb than the entire Commonwealth prosecution team and their law enforcement witnesses, I might add.
Teeth or claw marks, right?
Your Honor, I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all.
See how he tries to misstate what somebody said previously, and then he wants to try to pin her down on this and try to make her look like she's confused, and she's the one that's ever-changing testimony when he's the one that's doing all the spin.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
May I approach?
Yes.
When you first testified on June 18th, Doctor, you were asked questions trying to identify
He'll never refer to her as Dr. Russell right now, is he?
what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin, and you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay. Let me see.
Nature's best. Yeah, I think you're right. The judge last time said you could not say it was a large dog. I think she limited it to animal, if I remember right, from trial 1.
Thank you. That was your first testimony last year, yes?
Yes.
Yeah, he's doing grave digging right now, his own grave.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes.
after your consultations, do you remember changing that opinion regarding number 1? Do you remember changing that opinion?
No.
Yeah, think about it. She's not just dealt with doctors that are abusive to their female staff, but she's also dealt with prisoners. Can you imagine the way some of the prisoners might have talked to her, the inmates? So she's seen the nastiest of the nasty. And so Brendan is acting like probably some of the folks in prison acted here.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Okay, one guitar and two boots. Dr. Russell is a train wreck. What evasive, hedging, lying, cheating whore. You know, you're disgusting, so you're going to be permanently blocked. You're obviously a troll for evil, so goodbye.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canines,
Correct.
and the smaller ones are incisors.
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines.
Correct.
Okay.
Oh.
Did you?
And he goes on and on and on. Look at this. Judge never once says to him, "Move along. We've heard enough." Yeah, it's. But you know what? In the end, as much as it's painful to watch, keep in mind if this doesn't trigger the jury, then there is zero hope for ever getting a fair trial in Massachusetts. There is zero.
When you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did the report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have
He can't even understand that he's digging himself a hole by trying to explain that have her explain that it's canines, which is a trained police type dog.
any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say
Plus, she had more time to review the case because there was a mistrial from over a year ago, and she saw what an abuser of witnesses the prosecutor here is. And so, yeah, she did have to do more studying and preparing.
more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Top-
Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
Going to allow.
Do you remember that conversation?
Wow.
You said that the point of entry would be the bigger circle pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at
Remember
all.
that conversation
No.
we had?
He's just trying to act like a total jerk again. Harriet Fox asking why no sidebars about Hank's obnoxious, rude, crass behavior. Well, the one thing is when they are objecting, she rarely will sustain anything, and she'll say, "I allow it," and let him keep abusing this doctor verbally because this is helping the defense in the end.
Okay. And so, inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog.
Yeah, as a group, you got to look at them all. If you just had the ones on the far left, you wouldn't know exactly what they are for certain. But when you have a whole pattern, and that's the way dogs are used to ripping and tearing at an arm as somebody in a defensive posture, standing up, it's a no-brainer.
So if
Injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound
Yes.
up there, closest. I agree. Yes.
In fact,
You cannot win a case treating people this way, and the jury seeing all the deceptions that this guy's pulling, stunts he's pulling. You can't win a case like that.
you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me, yep, four, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for five and same for six.
Right.
Correct.
Right. True. What's a big deal? It's the pattern, the totality. That's what's common sense leads you to believe.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds,
Cat Love Dreaming Peach. So sad to see Carl that's in a total derangement. What happened to you? Karen is so guilty. Okay, well, if you're not concerned about the process, due process of law, you're not an attorney, I assume. And so if this is not bothering you the way somebody can treat somebody as sophisticated, elegant, and sweet and knowledgeable, the foremost dog bite expert in the world, if this doesn't bother you, then this kind of mindset is the same kind of thing that allows different societies to lock up and abuse all kinds of different classes of people. So that's pretty sad. And people like you that condone this deserve to be banned. So thank you for showing your true colors, just like Hank Brennan, because I just zapped you. So good riddance.
individually, you were saying that you could identify.
Again, I will say people that are anti-Karen Reed, they're the ones that are all deranged. They can't talk about the evidence or the lack of due process here. It's all a hate fest and name-calling fest. They cannot do anything but verbally attack people and call them names. So that's pretty telling. So it's like they're all drinking the same Kool-Aid.
Identified as a dog bite.
I disagree with that characterization.
Number two, what caused this wound, Dr.
Number two, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's
Okay, Miss Velvet, what do you mean? Did you hope you see my point about a couple of jurors smirking when Hank was doing this? What do you mean smirking? That means like they were enjoying it. Well, how do you know that? Where are you getting this from? Please be more descriptive. Like if you guys give me comments, please be more descriptive.
A punctate, little tiny, pinpoint almost, lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this?
Assonance, or he's going over the same thing over and over again. You know, if the defense tries to do that, she cuts him off. Enough, move on. So
Is
it's a sham
or is not
court.
a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction.
You lost a jury, Brennan. You don't understand this as a lawyer. You don't have experience of reading a jury. Don't you realize that you have to win over a jury and get them to believe you and trust you and like you? Do you realize that all this behavior you're doing, all the stunts you're pulling, completely alienates you to a jury, that they will not like you and they will despise the way you're acting, and they will be siding with the defense because of your very tactics and stunts you're pulling?
So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but
Yeah, see, Brendan's not even understanding the fact that he keeps talking about, is this dog bite? Is that dog scratch? Blah, blah. It's all dog, dog, dog. So guess what? And he's showing these photos up there. So she's just able to reinstate and reinforce all of her comments over and over again. And he's not smart enough to figure out he just keeps on digging his own grave deeper and
my
deeper.
question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines.
And that's what you're doing to impeach her credibility. It's by saying, well, not these individual 2 here and this one here and that one there. It's just lunacy
the
here,
big upper
guys.
teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these 2 scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these not exact, these 2 linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testify,
But gosh, if you can't say it was the right paw versus the left paw versus the right incisor or whatever the teeth are on the right side of the mouth versus left side of the mouth of a dog, I mean, come on, really? That's what this is going to boil down to, Hank, is how you're going to impeach her.
Last year on June 18th, you said that this was either teeth or claws.
Okay, anybody that says Brennan is a good attorney, an effective attorney in this case, doesn't know anything about being a trial attorney or a criminal law specialist. So take it for what it is. They've never tried cases. They don't know how to read a jury. This guy doesn't know how to read a jury because you never treat people this way. You never take a case like this to court. So that's what they had to do. They sold this case to the highest bidder, the person that they thought could do their bidding to be as vile and nasty as possible to try to bring down Kieran Reed. Help do the cover up of who really done it.
Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently, Mr.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the word that was used that's been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can
approach?
you just hold 1 second? Could you please turn the fan off? Jerry, is it okay if we turn the fan off so we can hear better? Thank you very much, Officer.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth, weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then, sorry.
Oh, go ahead.
Are you done?
Oh. Oh, yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was.
He's in his own little vacuum here. He has no idea how he's lost the jury, how they just cannot stand listening to him. He's an audience of one, or I should say two, him and the judge only. So if the judge thinks that she's helping things along by letting this carry on like this, she doesn't even understand that he's ticking off the jury and they're tuning him out and they're despising him. So even she's not able to figure this out. So they just think they can steamroll over people, and these jurors are a bunch of dumb idiots, bunch of knuckle dragging fools that they can just lead around the courtroom with hog rings in their nose and tell them how to think and act and vote.
An upper tooth, this is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
And so when you first,
I mean, think about it. She's untouchable. She speaks brilliantly. She has all the credentials, foremost expert in the world on this kind of stuff. It's an open and shut case with her testimony alone. And so this is no doubt a dog bite and or a dog's tears. But I think if your arm's up and you're trying to fight off a dog, they're more likely going after you with their teeth, and claw grabbings are secondary in terms of damage. Think about it. Also, he had his jacket on, so that would have protected him from some of the damage as well. So I think the teeth marks would have had much more chance of digging through and causing those bloody gouges in his arm.
described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth, correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today, you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You
Yes.
were asked, what do you think? And you didn't say without 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog
Oh
teeth?
my gosh.
Excuse
He's going over and over again. So they could really object and say, ask and answer. I guess you don't have to have a reason, but in any event, keep badgering this witness, Brendan, see where it gets
Do you
you.
think there's any way these two could be caused by dog
Right.
teeth?
We're just going round and round and round and round and round and round and round. There's nothing to talk about this. This is dog pattern biting and scratching. Enough said. And look how much time we're wasting. I mean, if I was on the jury, I'd be going like, yeah, some of you guys saying that you do this not even want to come back, but that's how the Commonwealth wins, is people that see this for what it is. You got to stick around and not leave as members of the jury, because maybe you're the one that could prevent it from being a hung jury. There's no way they
You're
can get a
saying that these two
conviction.
were caused by dog teeth.
They should be not guilty. Across
yes, could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing,
Well,
Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell. A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I
The
did.
posterior side?
Excuse me, pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly what
arm?
I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement
Okay, so Janai, you're saying that according to the Jess Machado show, the jury wasn't happy at all. Jurors who normally take notes out of their notebooks put their notebooks away and stared in the crowd, I guess, or what you're trying to say. So yeah, some of you guys are making comments like that. So that's what I'm saying. I think this should be game over. I mean, if there's any chance he thought he had to win this case, he kissed it goodbye with this doctor right here. Her testimony alone, not guilty. I don't care what you want to talk about, all this other stuff about the black boxes and the heat of the cell phones and all this kind of technical nonsense. This is what it really comes down to. What do people really trust and rely upon? Their own visuals of what the injuries look like for John O'Keefe.
dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic.
Yeah, see how he never brought that out through his own Welcher, explaining each tail light of glass, how did it break apart and how would it have gone through the clothes and how would it quickly go through the clothes and create that. I saw a comment from somebody today about that works in textile, and they said there's no way any kind of polycarb could create like a perfect hole like they have, like a dog, like we saw for the dog bites markings, the holes in John O'Keefe's hoodie. So yeah, it's all smoke and mirrors. Hank has to know he's got a loser case and he's not going to win it. So he's going down swinging, just becoming as nasty as he can.
dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that
Nasty.
these are a number of different dog strikes, and coincidentally, every single one of them lacks any wound to the underside of his arm?
Yes.
Yeah, the reason it's not on the other side because they're fighting like this because he's trying to block the dog, and the dog wasn't able to make a bite all around to the back side. So they're nipping at the front part of the teeth, not the entire open jaw over the arm or the right arm there.
Your claim is that a dog penetrated the sweater on the top,
It's just unbelievable.
but the
You see that tone deaf and clueless that he thinks he can beat up witnesses for not being able to explain every single little detail of the defense theory here on what happened. Yet he has nothing but the blue man painting his arm and then having a SUV back into him at 2 miles an hour. And that's supposed to explain how the taillight shattered. He never even brought that out. It's just really
lower jaw
crazy.
did not leave any wounds.
I'm claiming that
Yeah, Yeah, here you
This-
go. CV, you're
that's
saying
not what
the
I'm
same
claiming.
thing.
No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical
Oh, come on. Wise guy.
opinions.
Unbelievable.
Your medical opinions.
Okay.
Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event,
Yeah.
penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions.
Plus, he had clothing on. Hank's not bringing that out at all.
But yes, I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by the
Interesting.
tooth?
Objection, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, could you put that back up, please, was caused by a dog?
In and of itself, that part
Shame on
only,
you,
no.
Judge.
Can you tell us anywhere on Mr. O'Keefe's
This is
arm to a reasonable
despicable.
degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused?
Ridiculous. That's a
Any of those
ridiculous thing to
abrasions.
ask. Absolutely ridiculous. Of course, you're not going to know this tooth here and that tooth there, and this is from the bottom tooth. That's from the top tooth. This is just
I believe there are
insufferable
several areas
nonsense.
where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be,
Well, you have the
Specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
thank
Do you
you.
have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Drag this out, Brennan. See how you're scoring points with the jury here. You're
Did
not.
you ever change your mind about the source of these abrasions?
Golly, this is over
Can you
and
be more
over.
specific?
Did you ever claim that
Over and over and over again. This is so painful to watch, guys.
any of these abrasions were from upper
If I had anybody else supervised and I act this way in court, I would stop the court and kick them out of the courtroom.
or lower teeth?
Well, first of all, I wouldn't have to do something like that, probably because the judge would do something to get him online. Yeah, this nasty behavior doesn't work in a real court of law.
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth
Yeah.
or claws?
It won't let go of the
I
bone.
have
That's
an
right.
opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth?
You know, what if defense would have done that? Held up each thing of the tail light and said, "Do you have a medical what did they say for Welch, or a engineering degree of certainty or whatever it was, that this piece can you say where this piece caused medically certain degree of certainty or engineering degree of certainty where this caused injury on John O'Keefe's body?" They couldn't have done that for every little single piece of plastic. It'd be so stupid to say that, but that's what he's doing for this here.
Teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
It's just garbage.
Individually, no.
Absolute trash garbage what he's trying to pull. It's stunt he's pulling here.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders,
It's true.
wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than,
Think about it. I started at 1 minutes into this thing. And look, we're still at an hour 17. So we're not even done. And this has been going on an hour almost.
the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it? The distances-
Again,
Objection, Your Honor.
So there was a question at that, so I'm going to let that in.
Again, Dr. Russell,
What? There's a question at that?
the distance here, it's not insignificant, is it?
Mr.
Sham.
Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What
And
did you come up with?
visually, and I can see that there's a difference.
What was your measurement for this one?
Yeah, see, if you really thought she was incorrect, you could just make a few points, move on. And, but doing this, as you call it, bullying and nastiness for over an hour now is not gonna let you win a jury case at all. I can tell you that.
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did not.
Measure them, excuse me, did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, report, notes?
That's correct.
Why would you even go through the
Scam.
process if you're
So
looking
process is a scam.
at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, Doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with a car accident. That's what a fancy way of doing it is, right?
Fancy way of doing this. What kind of a smart aleck comment is that? This guy is so embarrassing. He's professionally embarrassing to see a guy act in this way in a court of law in America.
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So if you're-
methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes, I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really think?
I'm sorry, can you
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yeah.
That's a good point, C-Star. Hank, you don't even know where John was standing. Or if he was standing on the street, on the curb next to the street, near the flagpole. Keep in mind, we heard from Trooper Paul. It says that he got launched 30 feet and landed 30 feet from another direction. So where was he hit at? Where was the point of striking? So these guys don't know anything, and yet he's trying to go over these dog bite injuries with this kind of precision detail. It's just
Yes.
absolutely ludicrous.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree
Good
that
one.
what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of
Accident-
accident
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
She doesn't need to talk about accident reconstruction in terms of what car did what and how it spun around and how it veered off the street and all. Your experts couldn't even say where the vehicle was at when it supposedly hit John O'Keefe. So
No.
Do you know what ACTAR is?
Actar really?
ACTAR?
Yes.
No.
It's a certification group for collision specialist, accident reconstructionist. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
She just
No,
sustained
and
the
I don't know
objection.
any physicians that are.
And then he goes ahead and asks the question anyway.
Have you ever gone
Lawless. This is a lawless. I don't even want to call it a court of law. It's a court of. Yeah, I don't know. I don't know. There's not any appropriate words to describe this thing. Look, what is she doing up there? Thumbing through a magazine or something, looking at her phone.
to a scene of a car collision and done an investigation and written a report and reached a
What's that book she's
conclusion
got in front of her there?
about the cause of the car collision
Unreal.
and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources.
McRamble, you have a serious question. Is Hank using some real form of strategery here? I think he means strategy. As if being so annoying and incorrigible, then other lawyers will call us witnesses. I think it's him. I think this is the way he normally does trial work, and I think that's why they decided to hire him, because they figured he could get the most kind of tricks out there to bamboozle a jury into convicting Karen Reed. Because if you had any straight shooting prosecutor out there, they wouldn't be pulling all these stunts and alienating the jury like this. So keep in mind, if he thinks he's winning this game, which I don't think he does. I think he knows he's got a loser case, and that's why he's fighting this with such anger and vitriol here.
Including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay.
Right.
Wounds are definitely within my area of expertise.
Applied of
When
you.
you considered your opinion to this jury,
Wounds her expertise. Okay, not how cars were spinning out on a roadway.
that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different
That
things,
doesn't
like
matter.
the bumper, perhaps the taillight? Have you ever
Doesn't matter.
studied that
You
in
know
this
it.
case?
I'm aware of some of those factors,
Have you
yes.
studied that before you gave this
Studied.
opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And
photographs.
when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you
Not the
notice
exact height.
I noticed that
You don't-
there was a similar, that the height was.
You don't know if one of them had a longer arm than the other. You don't know if one of them had was longer waisted, shorter legged, all that kind of stuff. They can't say that this Welcher is exactly the same size as John O'Keefe. So and plus the height of the vehicle, he's not accounting for that height of the vehicle. There's a 5-inch difference in the height settings of that SUV of Karen. So
would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the brake was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see
it's just a prank, yeah.
that it matched up
Just keep
height-wise?
thinking this is a prank. This can't be reality
Close,
here.
yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of
Doesn't
a
matter.
possible collision.
That's not
Do
the
you
purpose of why
know
she's being
how
called there.
slowly or fastly Ms. Reed's Lexus was traveling on January 29, 2022
Yeah.
at about
Sort of
12:32
corruption.
a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there was several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
Who cares?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved?
This is the worst, one of the worst attorneys I've ever seen. Seriously. He has zero ability to present a case in a successful manner where he has strength in his arguments. He's able to articulate the facts, draw out the facts through the witness, get the witness here if it's an adverse witness, get this witness to concede flaws in their expert testimony. She has no flaws. And what he's doing is just badgering her with minutia that is actually just going nowhere, has no basis of an ability to discredit what she's saying. So it's really amazing that this is being televised to the world, and they got this guy up there doing a clown show and expecting a jury to convict Karen Reed with this kind of behavior and tactics.
From the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass
Have you ever
in the
looked
picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at
I
the pants?
don't know if I looked at the pants.
So when you say you didn't see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
let's,
Oh my gosh, she's not an accident reconstructionist. Okay, so he thinks he's going to score points asking stuff way beyond the scope of what she's called for. Keep in mind that even in the scope of testimony of his own experts, keep in mind the judge did not allow with the Welcher anything to come in about Trooper Paul, and they were both doing the exact same kind of testimony. So this guy, unbelievable. All right, this is going to go on for to 157. So
yes, we'll come to side letters tomorrow.
how many minutes are they wasting arguing this? So that's good. The jury just put all their notepads down and like kicking back. Oh, this is There's a
Dr. Russell,
absolute
before you gave your
elder
opinion to this
abuse
jury,
here.
suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Exactly. Good answer.
Did you look at photographs to see if you could identify
Look at her look at him like,
the land?
you know, that's a baseless question. You know, darn right. And trying to bring up 34 figure, shame on you. This is a court. You're right, folks. It's a court of corruption.
The dirt, whether it was flat and smooth, or whether it was bumpy, whether there was rocks or debris in that area.
Yes.
And you went
Now you're saying it's rocks or debris that caused injuries to John O'Keefe? Really? Where are those at?
there and looked at it.
No, you asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the
Tooth and
area
nail, yeah,
where
ironic.
Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of
Yeah, I forgot that. He used the word fastly.
excellent quality.
Good job, Hank. Brennan.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Go on. Keep in mind, folks, the longer this goes on, the more he's digging himself a hole, or a grave, as we should say, for his case.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered
Yeah.
excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries,
What
those
the heck's
injuries
that
to
do with
different people could
anything?
vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally
group of
dissimilar from one
people?
another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Bizarre.
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases
Not
I'm sure you've
relevant.
studied where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are the instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
Yeah.
No significant
Makes
injuries.
sense.
Correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
Point.
When a car
So
or a vehicle
what?
is involved, have you ever been involved in treating patients that receive injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken
Yeah,
plastic?
Yes.
I think if he's this abusive towards her, imagine how he's going to come across to Arca. He's going to lose his mind on Arca.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions about what his body posture was, how he may have hit a motor vehicle. Did you consider that?
I considered several scenarios,
And when you
several different,
Yeah, unlike Welcher, who considered none, but the one he was spoon-fed.
positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been standing, kneeling, sitting, lying down on the ground? I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived
7
at
years.
scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field.
Caroline Rivera. I turned off super chats. What was it, a day or two ago, because I was telling people not to contribute, to give the money to Karen Reed Defense Fund, and so I turned it off. So because we don't need your money, and Karen Reed's defense team does. So I went ahead and turned that off.
Near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions,
Yeah, where's the debris field? At 6:04 in the morning. There was no debris field.
did you ask anybody for any more
It sort of showed up over the next couple weeks.
information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Could I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that that there was one shoe off, correct.
Were you aware that it was wedged right up against the
Well,
curb?
Cossie.
Were you aware of that?
I'm aware, I have been aware of that, yes.
And when
What
you
the heck
came
did-
to your
What the heck's shoe got to do with the dog bite?
conclusion that you offered that
Like that can't be planted
The injuries
there.
are not
Like
con-
he didn't take his shoes off going into somewhere in the house.
consistent with a impact or car collision, was this photograph part of your consideration?
No,
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
no,
Do you see underneath that hat, there was not 2 inches of snow, it looks like dirt and grass?
yes,
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please.
Yeah. Brennan thinks he gives a good summation with every witness, and he's doing good. What a joke, says Brittany.
When
He
you were
thinks he
reaching
can
your
will his way to
conclusions,
victory.
you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your study, in the foundation of your opinion, that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus
Move along.
was broken
Gosh.
early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having a trouble
Okay,
understanding the
it's my
question.
fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle, yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken and missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken, in considering this conclusion?
Yes.
So he's basically trying to make her an accident reconstructionist, which she wasn't trying to be presented as such by the defense. So he's actually digging his own grave even deeper here with this. He's that bad at tactics and strategy as a lawyer.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time it?
A broken taillight in and of itself could not cause those injuries. There would
Thank you.
have to be multiple projections from the vehicle
Blew up in your face there yet again, counselor.
that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation,
Awesome.
you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after,
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
and it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we have-
the vehicle parked, yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear tail light is missing pieces?
You can't tell
I
that.
can't even see.
The left side of the vehicle was towards the house, so it had more protection from snow and ice, and the right side wasn't. It was more facing the direct line of the blizzard. So you cannot
See that.
say
Oh,
that.
yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case, you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision. Do you listen to witness testimony, or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I take witness statements? Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you
I mean, she's just shooting down every angle that he's trying to use for his deception game with the jury.
listened to the statements of the defendant herself in this case regarding potential impact?
No, what do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring?
So statements Karen Reed made to the news stations or the Dateline or ID Discovery, that matters, really?
Referring to what you've asked me previously about
You're talking about physics.
did I hit him or something of that? What do you mean specifically?
Have you seen any of the media?
This shows you, as a lawyer, you don't ask questions of a witness you don't know the answer to, because it can absolutely crush you and embarrass you. And this is what happens right here.
Statements by the defendant, 2020 Nightline docuseries. Have you seen any of these statements in your analysis of whether or not there was a impact or collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not.
Good
And I'll
job.
tell you why.
Please do.
Because
Here he's so clueless. She is so brilliant and so much background in both ERs and also in confinement settings where you have inmates with dog bites from the patrolling prison guards. And he asked her this question thinking he's going to trip her up. Look what she says. And this is like perfect defense for Karen for all these little video clips he's been playing about Karen saying stuff about, whether she did it or not, or did I hit him? Could I have hit him?
she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year later, year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
There
Now,
you go.
when you looked at the
There you go. This is something the prosecutor brought out. If the defense would have tried to bring this out, Hank would have objected, and Hank is not sharp enough to understand. He keeps getting deeper and deeper in the pit he's digging, his own grave.
clothes in this case, Mr. O'Keefe's clothes, you are aware
we just got to see the humor in all this. You know what? Despite all the abuses going on and the tragedies for Karen and her family with all this injustice going on, it's also an injustice to John O'Keefe. It's a disgrace to him and his family. They just don't realize it as surviving family members.
That those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
He's going to bring up DNA, and this has never been brought up before. So he's going to try to ambush her with something that he's never brought in his case in chief. So,
Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor, like approach, please.
Okay, come on up.
yeah, look at all the jury's now being reminded of all those puncture holes from a dog. And really, you'd have big plastics not puncture through fabric like that, as somebody pointed out to me today in a comment. It makes sense. This is common sense. All right, let me jump ahead here. You're going to hear Leslie argue for a mistrial with prejudice. So it means I basically dismiss the case. Karen's acquitted in essence. Similar to what happened with Alec Baldwin for government misconduct. So they're saying that basically he shouldn't have brought up the DNA. This backdoor way of doing it, did not present it. And it's prejudicial to such a degree for the defense, they cannot undo this prejudicial comment, making them think that this thing was cleared of any dog DNA when they did the way this shirt was handled and contaminated. They didn't have proper chain of custody and treatment of it. So did they really test it for dog DNA? Who knows? I don't believe anything these guys say.
We're doing what we will give you the morning recess, so that's about a half an hour.
So they go to morning break.
All right, Mr. Alessi, I'll hear you. Mr.
Let's
Alessi,
unload
I'll hear you.
here.
Thank you, Your Honor.
Mr. Brennan, can you remove? Oh, okay, it's being removed.
This goes on for 12 minutes. His argument here. So
Thank you, Your Honor.
judge is going to deny it, of course.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA.
Normal speed here.
As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. with regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation.
I mean, think about it. Defense can't bring up stuff about Trooper Paul in crossing Welcher, and Welcher even looked at his stuff. He even looked at the reports of Trooper Paul, and then he tried to like backtrack from that part as well, because he knew that could bring that out in cross-examination. The judge kept it out. So this is like so much one-sided rulings over and over and over again. So this whole thing is a walking mistrial and a trampling of due process. So I'm not going to even cover the rest of this point, because we all know what the answer is at the trial level here, which is nothing's going to happen. The judge says, go ahead, continue with the line of questioning. So she can be cross-examined on DNA that was never even brought out by the prosecution's witness. Unbelievable. This is like so much an affront to due process. Unreal. All right, I'm just going to jump ahead here. We get the Honorable Dr. Russell back here.
Mr. Brennan,
Thank you.
Brennan can do no wrong. Trial by ambush. Violate the Constitution day in, day out. It's not a big deal in this so-called court. It's a court of lawlessness, that's for sure. Yes, Sarah Jackson, I agree. There's nothing he could do
Good afternoon, Dr. Russell.
that would get
Good
the
afternoon.
trial case called.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You
my
looked
God, this is
on
still
direct
going on,
examination
guys.
at a
It's
photograph
still going
in
on.
Dr. Welcher's presentation.
Jury's still there having to
And had a
listen to all
photograph
this
of a
garbage
person
from
who had
Hank.
been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of
There's so many reversible
which,
things.
which one specifically?
There was a gentleman
I've
lying
seen.
on the ground.
GWTHGO, yeah, this DNA ruling. There's so many things that are automatically going to get this thing bounced on appeal.
His face was redacted.
If there's an
Oh, that one.
conviction,
Yes.
Remember
there
that
won't
one?
be a
Yes.
conviction.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was, what you were trying to deduce or
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body brakes, do you have any studies about the frequency or the likelihood of lower body brakes in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body brakes?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks.
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
I saw that image.
Yeah, of course.
Consider what's called the text stream data. Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you
She's
look
supposed
at
to
any
be
of
an
that
expert on
information before you formed your
everything.
opinion?
Hanks is throwing the kitchen sink at her. He's trying to just get her rattled. And look how professional and smooth she is.
I looked at it,
Yeah,
but I
brazen
honestly did not
lawlessness
understand
here.
it.
Yeah, it is
Did you
outrageous.
ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that
Yeah.
information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't. Well, I didn't understand it. And I didn't know that if any of the attorneys understood it actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had. My understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve. Yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it, excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So yes, I am aware that there was some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion?
Objection, Your Honor.
Sustained.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, in giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA,
That's correct.
and there's no identification where the pig DNA came from, is there?
I don't think
Maybe from a dog chew.
so.
So when you saw the information, after you claimed there was a dog, prove it, John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes,
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could
Without
be
no
no
foundation. What a smart aleck. This guy is so.
dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. You can ask it differently.
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual
Oh,
opinions to a reasonable
please.
degree of certainty?
Please.
It would be best
Like you've done that with your joke witnesses with bogus degree
to go through a
credentials.
process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. If you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before,
Unwilling to
correct?
change.
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm
Oh, sorry.
You can't tell us anything based in fact to support the claim that something
Based
was
in
wrong with the testing
fact?
of this DNA, can you?
Not in fact, but again,
You haven't even introduced it. My gosh, this is not even. This is like on so many levels is like absolutely laughable. But this is a court, really a court of law.
and you have to go
You can bring up something like a DNA test through an expert on on the defense case in chief that you never brought out on your case in chief. I've never seen anything like this.
through a process. If you expect a
In a real court, you'd get chewed out by the judge and probably would get a mistrial granted, but not here.
certain diagnosis or a certain finding on a lab test and it doesn't materialize, and you wonder why, and you want to know, was the test done correctly? Was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know
But they never swabbed John O'Keefe's body for dog DNA, right?
about the transportation or
And the way they handled that shirt was contaminated. There was no proper chain of custody and bagging of it. We saw it laying on there on the hospital floor.
the chain of custody.
You were a medical examiner, weren't you?
Yes,
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
yes.
Did you know at the time Dr. Scortabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
Way to stand up. This guy is so unbelievable.
You can't tell us one step that went wrong with that DNA process, can you?
How she doesn't know anything about it. This is like I would object at this point. I don't know why they're not objecting here. This is an app to put her through this. She's not a DNA expert. She was never called for this purpose. So just bringing up all this tangential stuff has nothing to do with her expertise. in her opinion, and yet something that's directly tied to the opinion of Welcher, i.e., Trooper Paul. Defense can't bring that in. So this is I have
The process,
zero
no.
respect
In fact, you have admittedly
for
very
this
little
sham
experience with DNA.
of a process.
I have little personal experience with
They are
DNA.
evil.
And
to the
yet,
core.
although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist,
What a guys!
and I'm trying to,
All right, I really
to understand why it could have been negative.
unreal.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you
So basically, he doesn't have to call anybody to testify to DNA because he's just saying it's a given, and she has to adopt it. Otherwise, he's going to completely
would not
go
expect
off
it would
on her,
leave little
badgering
fragments of
her,
satellite shards in
trying to make her look like an idiot for not agreeing to all this DNA stuff.
clothes, would you?
Correct.
But she holds her own.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight?
Yeah, I mean, the clothes were wet. We heard how they had kept it up the DA's office. You're telling me they didn't have a chance and nobody could have washed it out? You're telling me they couldn't have cleaned it, put it in the laundry, try to get some of that dog DNA out of there?
That came from the defendant's motor vehicle.
Objection, Your Honor.
I'm going on 11.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Okay.
Unreal. I've just this trial keeps getting more and more of a. I mean, it's almost like something you'd see maybe in Nazi Germany or something. Everything in Nazi Germany was done under color of law. Here, they're not following our laws at all. This is not the
All
way law in
fragments.
America works.
Shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt.
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr.
Doesn't change
O'Keefe's
the physics.
arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass,
Where were they in the photos? Where were they in the clothes? Did we see pictures of them on the clothes themselves?
can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass,
Unbelievable.
can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
It's just utterly insane, crazy how the prosecution theory is, and they think jurors could buy this garbage.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as
Who says he even fell to the ground? You haven't even proven that.
he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance, a little distance, he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
Do you think,
Oh,
Do
good.
you
You
know-
brought up initially 60 feet. Now it's 20 feet. Yeah, they keep changing their story.
know where his body was
Good
found
one.
on the side of the road?
Yes,
Do you know if his body, before it rested, moved or slid on the ground?
yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after
Good
the
one.
collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of
She just got done saying it. Where's the objection?
medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
Great.
I have no further questions.
She just killed all of your cross damage. You tried to bring up everything, kitchen sink, everything, and you lost big time.
Okay.
Brennan made a fool out of himself. And look how long that lasted. All right, here's Alessi again.
Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan,
Yeah, Miss Red Velvet. Yeah, they took him to the evidence room at the DA's office to dry him out.
that he just asked about,
That's what Proctor stated.
these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right, and if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red.
Hey, can you guys please not do all caps? It's really hard on my eyes. It's just like sort of jumps out at me. It's more of an eye strain. So I'm doing this for several hours. So we've asked you guys not to do all caps. So please honor that.
Colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your?
How would they stay on the clothes? How would they stay on the clothes? Those little pieces of plastic, really? They would, that many of them, those tiny of them, little pieces would stay on the clothes? I don't believe this at
the size
all.
of these pieces.
16. So those looks like they're maybe a
They still had a debris field showing up day after day, several weeks after the 28th and 29th. So
16th of an inch
it looks like
or
a
less.
plant.
Okay, so let's go back, Mr. Wolf, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 1/16 of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions, so these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may,
All right, for the sake of
abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Wilson.
Dr.
why
Russell,
Brennan didn't have to. He can ask it any way he wants.
please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of
An
Mr. O'Keefe.
inch can call those deep
I
gouges.
do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each, he grouped these, I think 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
So this Kimberly Villanueva saying Brennan isn't stupid, don't discount the effectiveness coupled with Bev's help. So really, you think he's being effective treating people this way? You can just be a complete monster in a courtroom, verbally berating and harassing people and putting a spin on stuff and blocking stuff you're doing. And the judge is rubber stamping all this. You think a jury's stupid? So if a prosecutor thinks he's going to win this way, that's not very smart. Okay. A jury's not going to be this stupid to fall for all these antics and abuses. Okay. So.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, You referenced studies, and as part of your answer, do you recall that discussion with Mr. Brennan?
Yes,
Do those, are those studies peer reviewed?
yes.
And give the name, please, again, that we had gone over on direct.
If the jury puts their notebooks away, I wonder if they even bring them out again. They may. They've already decided he's destroyed himself with this witness. There's nothing he can do to impeach her awesome credibility and expertise. So they may not pick up their notebooks again. I think they'll be writing a whole lot less. I think it's game over. Hank's lost this case.
But give the name of the lead
toast.
authors of each of those studies.
Yes, so one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that the article was reviewed by other physicians in those respective specialties
So
of
if
the
we could
authors.
I'm sorry to interrupt you, Dr. Russell.
I'm
You
sorry.
finished?
The specialties of the authors, yes.
We could take that down for a moment. Your Honor, may I approach, please?
Okay?
If I could have, Your Honor, from Madam Court Reporter, exhibits marked for identification P, 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 and Q, Q, Q.
right.
And I'll start with P, 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 if I could, please. Thank you, Madam Court Reporter. May I present PPP to it? Thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. Demunich?
Yes,
Do you recall Attorney Brennan, in his questioning, asserting that you had no basis and there was no support for your methodology of pattern recognition? Do you recall that discussion?
Sustain in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
yes,
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper,
Right, I'm
lower
gonna
and
have to
upper. Maxillar is the
Jump
upper.
ahead here. Let's go to just a few minutes of recross by Brennan.
May I?
Yes.
He's not saying Your Honor. You spent all that time and just helped build the defense's reasonable doubt. You helped proving she's innocent. Do you
Dr. Russell, I
realize that,
asked you
Brennan?
questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When
He's just going to get meaner and nastier the closer this gets to the end.
Attorney Lisi had you look at a couple of
Oh, God.
case files from the
I don't
Journal
think
of Legal Medicine.
we don't need.
Let me ask you
voice.
about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
Look at that. He doesn't even know how to ask questions right that don't blow up in his face. He keeps asking questions out of her, and she keeps on blowing it up in his face, making him look like a fool.
That wasn't my question, so we're going to listen to the question, please.
All right. I can't
Those
listen to him anymore
articles,
either. So, all right,
whatever
let's
their
just go ahead
value
and
you
jump
think they are.
ahead. This is a major crushing loss. She just outplayed him every step of the way. He tried to trip her up. He thought he could pick her off with some kind of angle of questions outside her expertise, and she just nailed him to the wall every single time. Yes, she is amazing, as Brittany says. It looks like he sort of was shaking. Is that what you're saying? I'm not sure I saw that, but he's definitely acting angry. All right, so I'm going to jump ahead here to, we have a Dighton Police Department officer for 14 years, a sergeant, Nicholas Barros. Here we go.
Next witness is who? Who's the next witness? Yes, just tell me the name because I need to know whether we need to go to sidebar first. Okay, thank you. All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barros, Barros,
And where do you currently work?
the town of Dighton, Dighton Police Department,
How long have you worked for the Dighton Police Department, sir?
since 2011.
And what's your position there currently?
Currently, I'm a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties...
I can jump ahead here. He got called to show up, I guess as a courtesy, because the state police, Proctor and Sergeant Buchanan, were going to show up and seize Karen's vehicle at her parents' house. And so they asked the local police if they'd show up and be there during that process. So this is the officer that showed up. And he knew that they're going to get...
Was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company, with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there, and I also went in to ask how we're going to get the truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV? Did
I did.
you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV?
The
2
whole-
minutes, 20 minutes, something in between? Longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance.
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight,
Can you describe for the juror, by the way, which taillight are we talking about?
the
Article
right
here.
rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that
Yep.
description is?
There was it was damaged. The taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big,
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches. or
And
so.
how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in
Okay.
there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight,
Of what?
the Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barrows, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo, sir?
That taillight is completely smashed out.
So it's totally different there. It's
Does it appear that there are additional pieces
look.
of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side, where that large chunk is, that's what was missing.
I'm going to hand you a green laser
Go
pointer.
back. He's
When I
in.
was there. Towards that right side, where that large chunk is, that's what was missing.
So it's on the right side. It's on
I'm going to
the
hand you
side panel, not on the back
green
rear.
laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe you would remember?
Can you believe that? Brennan objects and the judge sustains it. I mean, this is unbelievable. This is
If the taillight,
Good
well,
joke.
let me ask it a different way.
a farce. This whole thing's a farce. It's not a court of law.
The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle that is depicted in this photo.
Sustained.
Huh.
We can take this down.
It
as
hurts.
you sit here and recall
truth
back to
hurts
that
the Commonwealth,
your
that's
observations.
why
And you
it
observed this
blocks
for
it.
over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have?
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately,
Why? What's the deal here? It's whatever.
was the black Lexus SUV towed and cleared
Walk
from the
the
scene?
truth.
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen, like for instance, the SUV is taken away?
When I cleared from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.
No.
I'd like to show you another exhibit, if I could. This is exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is Diamond Towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay?
Can we play this video?
Yes.
Thank you, Your Honor. Can you see
Look at
what's
that.
depicted in the still image of that video right now?
I can.
Just like he says, just a
ask
small
you if you'll
portion
turn
of
to
that
your right.
light on the
Concentrate on this area,
side of it, not on the back.
this area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 to 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13.
Let me go a little faster here.
Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area
Hank doesn't want that comparison to the Sally Port photo where it's all smashed
that I'm
out.
circling here. Do you see any red lens in that area?
No.
It takes a lot of courage to Sergeant Barrows. He's got a lot of courage because you know what? A lot of cops would just sit there and say, you know, I don't remember. I was wrong. I'm not going to get involved. Leave me out of this.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
You ever get promoted after doing this?
Lights, please. Thank you. Mr. Ryan.
Thank you.
That's a shame of it.
Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Oh, here comes the nasty beatdown.
Do you still work in Dayton?
I do.
At the time you went to the lead residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
I mean, he's just repeating all the stuff that was already asked on direct. So I don't know why attorneys rehash all the same stuff. You're just wasting time for the
Because it's your
jurors.
jurisdiction?
Or
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you, you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left, did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dayton back to Canton?
How long?
Yes.
I did not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the
Oh my
width of the damage.
gosh.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at the moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
So you want to look at what he's saying here, and that wasn't done for any of the supposed crime scene folks there at 34 Fairview. None of them are doing the stuff he's now trying to wire brush this honorable police officer with.
Correct.
Because oftentimes, well, you
Unreal.
respond to a number of
I
different
hope that-
events and incidents, don't you?
Is the jury smart enough to pick up on that, the double standard? You could not imagine a more double standard prosecutor than this guy here.
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did. The right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an
So he would not agree his memory was better that day. But he was in a head-on collision with some drunk driver. He said he thought he was dead. And somebody's coming at him 70 miles an hour, drifted into his lane. It says crews were completely mangled. He was seriously wounded. He wound up with broken bones in both of his hands and burns the size of softballs on his sides from the airbags deploying. So anyway, this guy's grateful and lucky to be alive. So
opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
why your officers never did on 34 Fairview? There's no
did.
supplements. They didn't
Inevitably,
even process chain of
You
custody.
were a witness at trial. I'm sorry. You were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
You're going to question a police officer whether he's sworn to tell the truth? I mean, what a shady...
I don't think I was asked that.
Well, you asked about to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024.
I don't think I was told to describe it in depth.
Would you ask questions about the damage to that rear rail?
he was, as I recall, he was called by the prosecution and not asked any questions by the defense.
Rear taillight last time you were in court.
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed,
Time has passed, yeah.
that you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed,
Correct.
that your report was
God,
respectfully
this guy's-
scanned,
Correct.
that you had heard
Brennan's just so nauseating to listen to. I mean, just the way just going over and over and over again, all this minutia, trying to just find something he can try to discredit
about-
this guy with.
of this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024,
Who'd
you
wanna
qualified
deal
your
with this
answer.
guy?
Was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer, and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, the reason why you used that qualification to the best ability and recollection is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense?
You know, he's all interested on who any defense witnesses talk to in terms of the defense attorneys. But you know what? That's why I was saying, like, with this sneaky, underhanded guy like him, if I was going against a guy like this, in any case like this in particular, if I was on this case in Texas, I'd be asking all these prosecution witnesses that had lawyers, I'd be have them point out their lawyers in the courtroom and asking how much they paid for their attorneys to be there all this time and coaching them through all the grand jury testimonies and preparing for trial and going over their statements and all that. So, and here he is doing something like he's trying to implicate this guy as being shady for talking to the defense
About this case
counsel.
after you gave your testimony on June 10, 2024.
Once.
Where did you speak? Who did you speak to?
Attorney Jackson,
Did you speak to him in person or on the phone?
in person.
Okay, don't. Okay.
What difference does it make?
You're not hesitating, are you?
No.
Where did you speak to him in person?
You're not
His
hesitating,
hotel.
are you?
How did you know where Attorney Jackson was staying?
See, that's all all this innuendo. Like you got some kind of sneakiness about you. You got some kind of shadiness about you. I mean, this is an honorable sergeant with Dighton Police Department. And that's the way you're going to talk to him.
He told me.
Did you find it odd to go visit an attorney at the hotel and talk about the case?
It was in their conference room.
Find it odd. Go to
Odd to visit him, really, at a hotel. Okay, what's the big deal? What's the point you're trying to make? Like, is some kind of like drug deal going on there, Brennan?
somebody's hotel to speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel located?
Boston.
You had Tully go meet Welcher at the hotel to go bring him, or pick him up at the airport to bring him to the hotel. What's the
I don't
difference?
feel comfortable telling you.
Sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson, his request. Do you know who Mr. Jackson was?
I did.
You know on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
What does all this matter?
I'm not sure of the other gentleman's name.
It was the one
he's
gentleman right here on the end?
Poke your
Uh,
eyes out.
the one
This
down there on the
is
right?
Brennan.
No, it was not.
Unbelievable.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came to court?
No.
The photograph of the vehicle in Sally Port, the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever,
Yeah.
ever suggested that that was in any way different than what you had seen in that.
Nobody asked me that.
You were asked to describe the damage.
Yeah.
And
Yeah, Jackson's from LA area, so obviously he doesn't have an office there.
you were shown that photograph.
Boston.
You never, ever suggested.
I guess in theory they could have gone to Yanetti's office, but if they're at the hotel and he's willing to show up, what's the big deal?
That there was a difference in the damages you see in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the tail light the day that I saw it.
That you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
Notice Hank doesn't bring out the fact that he testified for the Commonwealth.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged, it was cracked, and there was a piece missing but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So, in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
I jumped way ahead. It was still going on with the doctor.
You ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Any approach?
Yes.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you testify that your memory of distinguishing that photo is reflected in your testimony, right?
Objection.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And I should take a look at it.
Of course you will.
Can you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dayton on January 29, 2022?
It's not enough.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah,
And
correct.
you share those same difficulties with memory as many other witnesses.
Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, you're going to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Or something more.
Correct.
What a... Wow.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, next months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what'd you talk about?
Objection.
I'm going to allow it.
Over here. What'd you talk about?
Excuse me.
So that
I mean, we've already seen the comparison of the back tail light area from Mr. Reed and Mrs. Reed's residence to the Sally Port, it's a night and day difference. And this guy just corroborates that. And he's got to go
Okay.
through this kind of like wire brushing by Brennan. Oh, now watch this. The way he says over here when they come back. I think it's right after this break. Okay, hold on a second. Let me back up. I guess that's the reason for the sidebar.
So that, okay?
Next month.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what'd you talk about?
Here.
Objection, Your Honor.
I'm going to allow it.
Over here. What'd you talk about?
Excuse me.
So
Or
that-
here. See how
okay.
that's where he says it. Let me back it up.
To
right there.
what a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, next months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what'd you talk about?
Objection, Your Honor.
I'm going to allow.
So, in other words, why are you saying this could have been done face to face? He's basically trying to make it sound like this guy's some underhanded, sleazy, dirty cop. Really?
Allow it.
Over here. What'd you talk about?
Excuse me.
So that, okay?
Over here.
What my schedule was like
Look what he
coming
says.
up in the next
'Cause
month.
he looks over at the defense
month.
because they're having
Those
some
things all
internal
could have been accomplished
discussions.
by phone, correct?
Could have.
So the face-to-face meeting, what'd you talk about?
Objection, Your Honor.
I'm going to allow it.
Over here. What'd you talk about?
Look over here. You know, he's talking this way to this guy, just like again, treating people like dog meat. And you know what? People on the jury pick up on this. This guy with the name Burrows, he's probably Hispanic. So any people that are on the jury that are minority, you think they're not going to pick up on Brennan, Mr. Bully, treating people like this? So this is unbelievable. Can you imagine how this guy treats servers at a restaurant and stuff like this? This Brennan guy?
Excuse me.
So that, okay?
Over here.
He's saying over here. Unbelievable. Like, oh no, you look over here. You look at me. You don't look over there. Over here. So just very rude, unprofessional again. So, I mean, I've just never seen this kind of a sleaze factor in a court of law before. Unbelievable. But yeah, this guy's very, very professional as an officer, and being treated that way is just so disgusting to see. Yeah, the detailed report says Kate. Where's the detailed reports from Proctor and everyone else? Yeah, it's just so bizarre to have a judge this bad just throwing out all the normal fair due process of law you see in a court in America. To see this going on, and then you got a prosecutor that's a defense attorney that's just trying to throw roadblocks and keep out the truth. That's a good point. First, like Frida, this law enforcement officer has no skin in the game of Canton corruption. He does hold his own, makes him a great witness. Yeah, treats him like a dog.
You told us there was some background about being subpoenaed and time. Substantively, what did you talk about with the attorneys when you met them at their hotel conference room?
Other than that, they didn't go over my testimony. We just spoke about that I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't
Extreme
recall the date.
hypocrisy.
I'm looking for a date, just the general year frame. Last year, this year?
Probably June. Early in this year,
Are you having some difficulty with memory about that as well?
on a certain date, yes.
Not a certain date. Was it this year probably, or do you think you met them this year?
This year,
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes,
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
no,
Did they ask you questions about it?
no,
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight?
Objection.
I'm going to allow it.
Already asked and answered, but he keeps on getting to go over and over and over again, the same kind of stuff.
They
Sir,
ju-
I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
on the 29th of January. No,
The video that was shown to you with the tow truck, had you seen that before today?
yes,
Who showed it to you?
from seeing it on TV, and
Was it shown to you during your conference room meeting at the hotel?
it was not.
So you looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you, I'm just asking you. Have you been exposed to this case since you made those observations in Dayton on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory?
Objection.
I'm going to allow that.
Your Honor, give me approach.
Okay?
Now he's berating him about his memory. I mean, this guy is just a first class monster. I can't say enough bad things about how this prosecutor is just bombing it in front of this jury. He is absolutely insufferable. The most grotesque thing to see in a courtroom, but this guy acting like a complete, total monster is the nicest thing I can say about it. So let me jump ahead here.
Back in 2022, wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory.
He wasn't asked the right questions that and wasn't asked that amount of
You
detail.
testified in direct examination under oath and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it in Dayton. If we could have the ring video at 5:07:58, please. Have you seen this video before, sir?
I have.
Before you proceed, Ms. Gilman? Have you seen this on social media?
The news, social media.
I think all this green light stuff and whatnot is just making the distortion really bad, where you don't really see what it looked like.
Has anybody else shown you this video?
No.
Trying to hide the
How
red.
many times do you think you've been exposed to this video?
I don't know how this is allowed. Look at all that green.
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look to compare it to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. I understand. Good play this way. Turn the sound down. Thank you.
Why does it look green inside our SUV? That's not normal. There's no green cabin lights. Look at all that bright green.
Stop, please. Do you see that white part of the back rear light taillight?
Objection.
I'm going to allow it.
Of course you will. Yeah, the green filter.
Can you zoom in a little bit more? I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop. Can you bring it back and stop it? Back more. Open, right there. Zoom, please. You see, sir?
Look at all that snow.
I can see that.
It looks like some of the
That
corner.
consistent with the damage that you saw when you looked at that Lexus indictment?
And this is all evidence that could be manipulated in Photoshop.
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions.
I don't know why defense isn't disputing
This
that.
was a snowstorm, kind of like a
Alteration.
blizzard that day.
Yes.
And when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing.
Yeah,
Yes.
And there was snow coming down on top of
that's true,
everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus indictment, you didn't go over it and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
We have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
There's no depression of the snow area there, so you can't go by the coloration. And also, you have the fact that the vehicle was to the left side; it's close to the house. And if you've lived in any kind of snowy climate, it's not uniform across the vehicle, and if the snow's coming from the right side, it's going to get iced over, a little bit more snow over it than the other side, the left side. So you can't compare the two and say that there's any of the red missing. And like I think I've seen on another YouTube channel, is it BN Trouble 31, where they something like that. They showed how there would be a depression of the snow if that light was bashed out at all. So anyway, this doesn't show anything.
Missing, yes?
Looks like snow is packed on it.
taillight there?
Does not.
This is before you saw the car in Dayton? Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear taillight and the missing parts of it, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay, lights on, please, Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant,
Yeah, that's true. Brendan was really smiling when he left the court after the arrest. He thought he was so wonderful and winning this case so far.
did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain this to the form, Mr. Jackson, is
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct. Surprisingly.
You remember being in Dayton, correct? Being called out to Dayton to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that? Right?
Mm-hmm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
Yeah, I don't trust anything these guys present in court.
You were asked whether or not you saw Trooper Proctor
Judge allows a metadata to be destroyed. So
in any way manipulate
it's nothing but corruption from hell. This whole place.
that right rear taillight while it was out at Dayton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sallyport in Canton PD? I'm sorry, in Canton, in the Sallyport at the police station
I wasn't.
at 5:30 p.m.?
Sustain.
See, keep the truth out. Keep the truth out, Brennan, and the judge is going to back you up.
At any point, did you ever go to the Sallyport at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sallyport?
Objection.
Sustain.
You were
All right. Well, that's good. The jury can see the more truth blocking efforts by the judge.
asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
Objection, Lucas Jackson.
So that's stricken, it's beyond the scope.
the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken, correct?
Sustained.
You and I met
Really?
in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Yes.
Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should
Yeah, that's actually, I'm surprised defense just doesn't keep going through and ignoring the judge's ruling and just keep asking the same question a different way and just make her call sidebars all the time. Just bog them down with just trying to push this line of questioning through. And the judge is not one that is able to control things very well. She can't do anything except help the prosecution. So you just sort of got to, how should I say this? You got to just push your agenda through and be an aggressive advocate. And anyway,
be directed?
this is
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw it? Any
No.
difficulty whatsoever?
No.
Do you remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you
Yeah.
on my direct examination? No.
this proves a cover up, folks. This proves a cover up.
Has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up. It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set.
Thank you.
All right, so jurors, I know I need to talk to lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing out witnesses. So, those same cautions,
Okay,
please do not
that's it, guys. So overall, great day, massive day for the defense. I mean, with this Dr. Russell coming in and just trying to be made the expert of all things that the prosecution's trying to keep out. Brennan thought he could score points against her, and what did she do? She completely makes Brennan look like the fool. She is so credible, so likable, so believable, so talented, so intelligent in explaining and understanding dog bites and dog tears from their paw and claws. So anyway, then we have this honorable officer Barrows that comes in to be treated like this by Brennan, the courage he showed as well. This definitely shows that there was manipulation and damage done to Karen's back taillight area. And the question is, why would they need to do that? If Karen Reed really had hit John O'Keefe, they wouldn't need to manufacture any evidence. They wouldn't have to treat witnesses like this. They wouldn't have to stoop to this level. And so all this adds up to more than reasonable doubt. It's actually looking like they know she's innocent. That's why they have to run dirty with all this stuff. So it's almost 1 a.m. here Central Time. So I'm going to go ahead and sign off and plan to cover this again tomorrow night. Thanks for your support of justice for the Karen Reed family, and we'll maybe see you back here tomorrow night. Thank you.